Okay, welcome. This is New Conversations in Real Estate. And today I'm joined on the Zoom conversation with Walter Killmer, who I know quite well and who's an esteemed trust and estates attorney, now a bicoastal partner in New York and Los Angeles with Smith Gambrell and Russell. New conversations, as I've done in the past, the changing markets and real estate markets, which we are certainly in the midst of, um, demands new conversations and new strategies. I'll restate the question: what homebuyers might consider when taking title on a new home. You can conversation, and please introduce yourself.
Thank you, Michael, for that introduction and for the invitation to talk with you today. As you mentioned, I am a trust and estates lawyer and do estate planning and trust and estate administration work for my clients. The following is based on California law, although there are similar laws in many other states, but this is based on California law. As you know, Michael, it usually is not necessary to involve a lawyer in a residential real estate transaction in California. When my clients ask me to get involved, it is almost always about this very question of how should we take title. It is usually a good idea to consult with a lawyer about that because there can be many implications. There are three basic forms of title for residential real estate, particularly owner-occupied residential real estate, and we'll focus on that. And this is the same whether it's one individual or if it's a married couple or if it is two or more unmarried co-owners, family members or otherwise. So the first is simply taking in the name of the individuals or individual who is or are the buyer. That's very simple. Doesn't take a lot of effort or decision, and that's perhaps what most people do. The second is to take title in the name of a living trust, a revocable trust. And if one has a trust, that is usually the best way to take title. And the primary reason for having a living trust, as you know, is to avoid probate. The probate proceeding in California, probate system in California is complicated. It's a system that was set up to protect the interest of individuals who might be vulnerable and who need to have their interest protected, but the same rules apply to everyone. And so it requires going back to court for several different stages of the probate process. There are many fees involved, and it is why most Californians with significant assets own their assets through a living trust. So that's another possibility. The third possibility would be to hold title in the name of an entity, which could be a corporation or it could be a partnership, but a limited liability company is perhaps the most typical. And one thing I would say about that is that there is an impression that owning a home through an LLC provides some protection from liability. And there's some truth to that, but not as much as most people think. Because if you own your home through an LLC and something happens at the property, there's an injury or something like that, then certainly there's going to be a claim against the owner of the property, and that's the LLC. And the only asset that the LLC would have, more than likely, would be the home. And so your other assets should not be at risk if the LLC is the only party that is being claimed against or that is being sued. Now, the thing is, if this is your personal residence and something happens there, more than likely you personally are going to be sued as well. And so if that's the case, then your other assets are at risk. And so there isn't a lot of protection in that sense. The other reason for using an LLC for some buyers is privacy protection, and that requires some careful planning, perhaps going outside California for the LLC, but it can be done. It can also be done with a trust if it's done in the right way. But there are ways to do that that can provide some privacy protection, or at least make it more difficult for someone to figure out who the owner is.
Which is important. Privacy issues are important. So there is a cost attached to LLCs and trusts where individuals would not have a cost attached to those entities, correct?
That's that's right, Michael. And so if someone already had a trust set up, I would say, well, it makes sense for your trust to own property. But if someone's only significant asset is going to be the property that they're buying, and they want to avoid probate, and they have a very simple situation, then I might suggest that after the closing, they consider signing a revocable transfer on death deed, which would be a way to dispose of the property. That's another possibility. But you're quite right that if what you're looking at is privacy protection, you're going to need a special type of trust for that if you're going to use a trust. If you're going to use an LLC, you probably would go to a state where the publicly available information is less extensive than it is in California.
That is a myth. I mean, if you're determined to find out who owns the LLC, I believe you file with the state of California, and there are ways privacy you can find out who's who are the I guess managing members of an LLC. So it's a common. It's not a what would say a slam dunk by putting an LLC that you are going to be guaranteed any kind of an anonymity. So, and there's an expense to it. There's an annual expense, I believe, to
Yes,
maintain an LLC. So
that's true. That's true. And the other thing to think about with all of that is that what we're talking about right now is publicly available records,
right.
Secretary of State, real estate records. But think about all of the other information that is available out there about each and every one of us, and how easy it is to find who lives at an address. And that's information that is very hard to control.
Walter, I thank you. Work together, and highly recommend both call you up when they have any issues regarding title, property, estates, handling succession, etc. And I appreciate your joining me today. There, I think you brought to light some very interesting matters concerning taking title, and it's always sort of in a real estate contract. It's always sort of dismissed as and/or assignees. So give some thought to that. And what I'd like to know is, Walter, is there a best way to contact you in case somebody wants to further the conversation or, hire your services? Put your email down. Is that a fair way to?
Yes, email is the best way to reach
Perfect.
me. And what I would add to that is and I'll give you my email address.
You
As
don't have to, because I will put it on a card if people stick with the conversation.
Okay,
There is a closing card, and I will include your name and your email, and that would be the best way to handle.
excellent,
The best way
excellent.
to reach out to you.
So maybe the best way then to answer your question is when is it particularly important to consult with a lawyer, whether it's me or someone else?
Very
Because
important. Do it right, set it up right, and you'll have a successful ending, or you have more opportunity to reach successful conclusions. So please elaborate on that for just a minute.
oh, sure, sure. So if you have a married couple and either of the spouses is not a U.S. citizen, there could be tax implications in how title is taken, and it's important to get advice.
And
If you have a buyer, whether married or single, and that buyer is not a U.S. person, not a U.S. citizen, not a green card holder, it's important to get advice because there could be tax implications, not so much in how title is taken, but down the road in terms of estate tax consequences. And then when you have multiple owners, if it's a married couple and there is separate property of either spouse going into the purchase, then it's a good idea to get advice about how to take title because that could have implications in terms of community property, divorce, disposition, death, and so forth. And then if you have unmarried joint owners, it's important to understand the different ways that two or more persons who are going to own property together can do so. And there are different implications depending on what form of ownership there is. There can be tax implications as well as implications in the respective rights of the owners. So those are the most significant situations in which just making assumptions and not getting legal advice could have significant consequences.
I would advise my clients in a purchase to reach out to you and do this before they release all their contingencies. But if for some reason that doesn't happen, this must take place before you close title.
That's right.
I mean, close escrow. Now, again, you can pick it up later. I imagine you can pick it up later and take title a different way or amend how you take title. One other point is, Walter, you're also very well versed on the international laws and how it would affect what you brought up about foreign nationals and non-U.S. residents. So it is very important. That is especially because there are U.S. tax implications that we, over time, have been exposed to and we've discussed on many. Walter, I thank you. Is there anything else, or we will wrap it up? And I'm just really, appreciate that you did this and you joined me this morning.
Well, thank you, Michael. I think that we've covered the main points well, and certainly I'd be happy to hear from any of our viewers who have questions about this area.
You were always a first call, a first recommendation.